Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. I made a joke yesterday. It wasn't a joke, it was a hypothetical in one of the arguments about the air conditioner needing to be repaired. And here we are. So I apologize for the temperature, but we'll do our best. Three arguments this morning. The first case is 240037, NuStar Energy versus Hancock from Travis County and the Third Court of Appeals. The second case is 240340, Gonzalez versus the Texas Medical Board from Travis County and the Third Court of Appeals. And the third case is 240132, Privilege Underwriters versus Mankoff from Dallas County and the Fifth Court of Appeals. The court has allotted 20 minutes for each side in each of the cases. We'll take a short break between the arguments, which can be viewed online and will be available later on today on the court's website. We're ready for argument in 240037, NuStar Energy versus Hancock.
May it please the court, Ms. Ulrich will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. This is a Texas franchise tax apportionment case. The question presented is whether the Comptroller's Rule, sourcing receipts from the sales of tangible personal property, presents a valid construction of the apportionment statute. Answering this question requires two steps. The first is proper construction of Texas Tax Code Section 171-103A1. The second step is determining whether the challenged subsections of the Comptroller's Rule comport with the statute once properly construed. NuStar submits that the Court of Appeals erred at both steps. The court improperly construed the statute and erroneously concluded that the Comptroller's Rule was valid. Now, however, this court has the opportunity to uniformly construe the statute, to impose a test that always applies, and to reject the Comptroller's inconsistent construction of the statute that imposes a sometimes test. I'll begin today's argument with proper construction of the statute, address the Comptroller's attack of the ultimate destination construction, and conclude with the reasons that the rule is valid or invalid. Turning first to construction of the statute. The parties have briefed many pages at this point, telling the court how it should construe the statute, and I'm certain that you will give that due consideration. But I'd like to focus today's discussion on Oral Argument Exhibit 1. This is a chart that distills all of the argument into a simple chart that reveals that only an ultimate destination construction gives meaning to each word in the statute and comport with a broader apportionment scheme.
Why doesn't the place of delivery confirm that the buyer consummated the sale in this state? What I guess I'm asking is, if we adopt your construction, is there some other test the comptroller must show to prove that the buyer consummated the sale in this state?
Well, under the place of, our position is that the place of delivery fails to reflect the market. And so that is why we're looking to
Fails to do what to the market, I'm sorry?
To reflect the seller's market for the goods. So a place of delivery says we're going to look at a point of transfer of possession. And while we agree that the statute makes transfer of possession relevant, it's how we consummate the sale versus, say, transfer of title or some other aspect of the sale. At the end of the day, you have to actually look further to what is the seller's market, and that is the buyer's location for the goods. So we don't see a situation in which place of delivery stands and then there is something else.
But the buyer was in the state.
Temporarily in the state.
Where does the statute talk about temporarily?
By referencing a buyer in this state. It could have simply said, we want to treat as Texas receipts sales of TPP in this state, or delivered or shipped. Or it could have
said a Texas buyer. Is that what you're really advocating, for that the buyer has to be a Texas resident?
That is not the test. We are saying that the buyer's location is the buyer's location for the goods. where is a buyer ultimately going to situs those goods to use them, whether that is use by consumption or use by holding them for sale, say, at a retail store.
Why would we substitute that for the place of delivery if the statute expressly says the arrangements of the buyer do not trump the place of delivery? So if it's FOB the buyer and title transfers at the buyer's eventual location, that doesn't matter. We're just going to look at place of delivery. So why would, I guess I'm trying to figure out, if we adopt your construction, what would the test be?
Of course.
For the sale to a buyer in the state?
Of course. So the statute does not dismiss the buyer's location. It dismisses conditions of the sale, and our position is that delivery and shipment are conditions of the sale. The same as title transfer, the same as in Lockheed Martin when this court disregarded the use of intermediaries to effect the sale. So it doesn't dismiss the buyer's location, and our test is that the buyer's location is where the goods come to rest in the buyer's possession. We have to finish transportation. We have to get from the seller to the buyer, and taxing when they're in transit ultimately results in a situation in where Texas and other states are seeking to treat one sale as receipts for their own taxes.
But isn't, regardless of the FOB point, saying that we're not looking at transportation?
Agreed. So that is why we're looking at their ultimate resting place in the buyer's hands. We are not trying to tax whether the goods are picked up by the buyer, whether the goods are delivered with the seller's own vehicles to the buyer, or whether a common carrier is used. We are always looking to the ultimate destination for the goods. That is the buyer's location.
You seem to say that the ultimate destination is where the goods are deployed or used. So in this case, it would be international waters, and then not subject to tax by any United States jurisdiction or really any other jurisdiction. But often purchases are consummated and the goods are in the hands of the seller chooses to deploy or use the goods, elsewhere. I can buy foreign currency in Texas and then take it with me to Europe. I don't use the currency in Texas. I can't use the currency in Texas, but I will use it in Europe, but still is a transaction that occurred here. So I'm trying to figure out how we would distinguish. It seems like your test is sort of where the goods are eventually used, not where the buyer takes possession.
Correct. It would not be where the buyer takes possession, because in the situation where you have an out-of-state buyer temporarily coming into the state, we do not view that as properly a Texas receipt or a Texas sale, because the goods are immediately being transported outside of the state. Now, if there is a concern about nowhere receipts, meaning, all right, a buyer picked it up at a Texas port and then they took it out to international waters, such as this fuel that cannot be burned in Texas waters. The reality is that the Texas legislature has already said that nowhere receipts are acceptable. So Texas has enacted a market-based apportionment scheme for all receipts other than services, as y'all addressed in Sirius XM. So we are looking to the destination and the market. Market-based sourcing is a policy choice that a state makes, because what happens is you encourage corporate citizens to locate within the state because their income is apportioned based on where their customers are located. So they're not punished or receiving a higher tax bill for having a presence inside the state.
But I thought you just said it wasn't based on where the customer is located. It was based on where the product is used. Those could be different, right?
In the sense of, you mean like, say, the buyer's principal place of business
Well,
or
I don't
domicile?
know. You were the one who was saying that it was based on where they're located.
I am looking at the buyer's location for the goods. So that is not necessarily, say, a corporate headquarters. It could be a retail store where they're going to sit on the shelf. So ultimately, the seller will be tasked with having visibility into these different locations.
How is picking up the oil and sitting on the shelf of a ship different than sitting on the shelf of a retail store, both in Texas?
Well, the oil is picked up at a port where the vessel is there for a very brief period of time, often 24 hours, and then it is not put in the fuel tanks.
It's stored
Right, yes.
in Texas prior to the purchase, though.
The seller is storing it in Texas. The
Right.
buyer picks it up, puts
Right.
it in a tank in their vessel, drives it away, does not burn it or use it until they get to international waters.
But they
Where am I
store
missing
it,
the facts?
they store it on the ship in
For
Texas.
9 miles. However, they don't ultimately consume it or use it, which is generally, when we look at market-based sourcing, we are trying to recognize the value that the consumer or market states attribute to the seller's income. And so generally that has been viewed as looking to the point of consumption in order to figure out where the seller's market and or buyer's place of use properly lies.
Is it important that the fuel cannot be used in Texas, or is it that the buyer just will not use it in Texas?
I don't know that it's critical that it cannot be used, but it certainly gives us additional comfort. I mean, I do believe that a seller can obtain documentation or certifications regarding the intended destination for the goods from a buyer. However, in this situation or other situations where you may have federal laws or state laws regulating the use of a particular product, here that gives us additional comfort of, regardless of any piece of paper that the buyer may give to NuStar, we know that they will not be able to burn this fuel in Texas without.
Suppose it was
penalty.
just a single kind of fuel. We didn't have this oddity of a particular sulfur-based fuel that we can't use near our coast. If the buyer took them all in tanks rather than put them directly into the tank, just enough to get to international waters, and then all the rest of it, same exact fuel, but they're just put into different tanks that are not already, in the combustible engine or whatever, would your answer be the same?
So using some and then moving some in transport.
But make it 2 transactions. Transaction 1, I'm going to buy, 0.5% of what I need to get to Europe or wherever. And that's just to get me the however many miles it is to international waters. And then the second sale, 99.8%, is going to be just in tanks that I'll then immediately put into the engine in order to get me to Europe. But it's the same fuel.
Right.
And it could have all been put in the tank, but it just wasn't. What's the taxable status of that?
I think if you were using it in Texas waters, that would be a Texas receipt. If you are
So that's the
moving it-
first one.
Correct, so that would be a Texas sale. However, the second one where you are, and to your point, I don't necessarily agree that it is storage. The goods are in transit. They are not being stored in Texas. If you pick it up on the vessel and then you have to move out for a certain period of time, I disagree that that's storage. And so to answer your question, those would not be Texas receipts. And if you bought it all together in one transaction, there's a situation where you may have to make an allocation similar to services where you have to figure out certain steps performed in Texas versus outside the state.
So what statute would you point us to? This statute talks about delivery or shipping, and it talks about buyer in this state. None of those things seem to have anything to do on their face with consumption. So what statute would you point us to say we should read this as if it's referring to consumption?
I look at the entirety of section 171-103, the subsections together. All of them but the services subsection look to the asset being sold, used, or here in Texas, whether that's a rental of TPP, use of certain types of intellectual property, real property rentals. And even with respect to services, at the time that language was enacted, services were really a localized transaction. Both the service provider and the customer receiving the service were in the state. However, as we have moved into a society where we actually have interstate services, we see a shift there to market-based services with, say, the statute that governs internet hosting services. So those services that are more digital and tech-heavy that can easily cross state lines, the legislature has made even more clear we should be looking to market generally for Texas sales factor apportionment.
Well, and isn't that the key point, that the legislature has gotten very detailed on the specific type of transaction or service or good and said, in this one, here's how you do it, and this one, here's how you do it. And so there isn't necessarily an overriding principle that you use to come in and sort of alter the text for whatever type of good or service is being sold.
I use the fact that Texas chose single sales factor apportionment, not 3-factor. We're not going to look at payroll anymore. We're not going to look at property anymore. We have done away with factors that were intended to reflect the seller's presence in this state and decided to look to sales. And so that is informing the way I read the language.
Right,
And-
but we said that in XM radio, but we also said that the legislature could easily designate the place of receipt or the location of the customer as the site of taxation. In other words, that is right, but the legislature can craft different taxing rules for different situations.
Yes, I read that portion of SiriusXM to basically be pointing out services look to origin. If the legislature wanted to go to destination, look over here at the TPP revision because that's what they're doing. And so my point is, it is destination with the overlay of where is the ultimate destination, where is the seller's market. If that is our mandate per the statute, is to find the destination for the goods.
So what's your best argument, just grammatically? Like, property is delivered or shipped to a buyer in this state. How do you get from those words to the destination test that you have in mind?
Of course. The meaning that I assign to delivered or shipped is the weight that it pulls is it helps us focus on destination. So historically, sales of TPP were sourced in a number of different ways. Some look to origin, some look to destination. Delivered or shipped helps us look at the end of the transaction, not the seller's acts. And then it also, we have to recognize it even though it points us to destination and it helps us understand where the sale is consummated, and it blocks out, say, sourcing or consummating sale based on transfer of title, because you can have a sale consummated in multiple ways. It tells us we are going to look at transfer of possession, we are going to look at the ultimate destination. However, the delivery and shipment points are a condition of a sale. They are inherent. You have to get the goods from the seller to the buyer.
So could I just ask unfrozen caveman justice question here? The ship takes the bunker fuel. It's in Texas to take delivery of the fuel. Why then isn't it a buyer in this state if it's in Texas to take delivery?
Because we say it is not the temporary presence. It's not even the buyer's domicile or their principal place of business. We are trying to look at the journey of the goods, the buyer's location for the goods. And so when they come in the state to pick them up and take them out, that is not the destination or home for the goods. They are still in transit at that point. And so
it's a use test.
Ultimately, yes, it is a point of use, and we think that that has parity with the remainder of Section 171-103. And it ultimately gets us to a point where we are not going to have different sourcing outcomes depending upon how the goods are transported. If instead of coming to the port to pick up those goods, a barge delivers the fuel to the vessel 12 miles off the coast where we're no longer in Texas waters, we now have an out-of-state delivery. Should the fact that the buyer tied up to the dock versus had them delivered change the outcome of the sale? And then similarly, we get to a situation that we haven't talked about yet with shipments. Under the Court of Appeals
Counsel,
interpretation.
your time has expired.
Oh, I'm so sorry.
Not a
I
problem.
will
Thank
save
you.
that for my rebuttal. Thank you.
We'll hear from the respondent.
May it please the court, Mr. Rocha will present argument for the respondents.
Good morning. May it please the court, Dimitri Roach on behalf of the respondents. The Court of Appeals correctly applied the place of delivery test and approach to the apportionment of gross receipts, which is consistent with the unambiguous statutory language of the tax code. NuStar has the burden and failed to overcome the presumption of the Comptroller's Rule that it was valid. Therefore, the court should affirm the Court of Appeals decision. The statute is straightforward, and NuStar's approach is fundamentally atextual. Here, NuStar sold fuel in Texas, the fuel was delivered in Texas, and the customer took possession of the fuel in Texas. That's important.
So you agree then with your friend on the other side that if a barge were to take it 12 miles out and the sale were consummated there, that this would not be a Texas sale?
Yes, if the property is shipped or delivered outside of Texas, then it is not a receipt under the Texas tax code. Looking at the relevant statutory language, it ambiguously provides that Texas is a place of delivery state, and NuStar is subject to the tax code because its business falls under the statute. I do want to emphasize, remember, this is a gross apportionment tax that reflects NuStar's privilege of doing business in Texas. There's a lot of focus on the buyer here, but this is a tax on the seller. I do want to emphasize that. The unambiguous language provides that if property is delivered or shipped to a buyer in the state, it is subject to tax. One thing that's important in the exhibit that was filed yesterday, and if you look at Exhibit 1 to a buyer in this state, the second bullet point for NuStar's construction states, this is the destination at which the goods come to rest in the buyer's possession after transportation has concluded.
What are you looking at exactly?
The petitioner's Exhibit 1 under NuStar's construction, it's the green column,
Okay.
and then to a buyer in the state.
Third
Okay,
box
third
down.
one down. Okay, I gotcha.
And looking at the second bullet point in that box, it says, this is the destination at which the goods come to rest in the buyer's possession after transportation has concluded. That is essentially what petitioner has stated today at argument, but that language is nowhere in the statute. And because of that, petitioner's claim fails.
So I think the argument is that buyer in this state is the language, and we ought to read that language consistently with Texas's use of a single factor franchise tax apportionment method when it's premised on sales. So when it's, and that would lead to the conclusion that a buyer in the state means that the buyer's, it's the ultimate destination of the goods that is the point of delivery. I think that's the argument.
Yes.
And so what would your response be to that reading? And noting that, buyer in this state is not, doesn't directly modify delivery.
Correct. And I think that goes back to the original point, is ultimate destination is nowhere in the language. And in fact, if you look at NuStar's argument and the case they rely on, much of the argument doesn't even go to ultimate destination. It goes to consumption. And that's a word that obviously is not in our statute and is actually not in a lot of the out-of-state court decisions that NuStar relies on. And those out-of-state court cases usually rely on what we call a dock exception, which is not what we have here either. But essentially, NuStar is trying to create a new exception, a combination, a hybrid of ultimate destination plus consumption of it.
Which out-of-state case involving a language that's like ours best supports your position?
I would say the Hercules case from Utah. But I want to step back. If we're looking at case law, I think there are two cases in Texas that are very important that support our case. First is the NSearch case. That was a Texas Court of Appeals case. It was cited in the Court of Appeals case in this case. But that case involved sales and delivery of natural gas in Texas to interstate pipeline companies for eventual sale outside of Texas. And there, the NSearch opinion stated that the business was done in Texas and therefore was subject to tax in Texas under the gross apportionment tax. And this court in Lockheed Martin actually cited the NSearch case and stated that it takes no issue with that decision. And that's obviously the Lockheed Martin's just from a couple of years ago, a decision from this case. The other case I want to refer to from Texas is the SiriusXM case. And it's been mentioned earlier, obviously it dealt with 171.103A2, which was dealing with for service performed in the state, but there's very important language in that decision that applies to the case that we have here. One thing that this court pointed out in the SiriusXM case is that the legislature could have easily designated the place of receipt or the location of the customer as a site of taxation. In fact, the legislature did so in the immediately preceding provision, which calls for the apportionment based on each sale of tangible personal property, emphasis added, if the property is delivered or shipped to a buyer in this state. Later on, this court also said in SiriusXM, said the focus should be on the statutory words themselves, not on extraneous concepts like receipt producing or end product act, which do not appear in the statute. And that's what we have here from NuStar's argument. New language about consumption, ultimate destination, all these words. None of these words appear in the statute, and they're completely atextual.
In the statute, in this state modifies buyer, and the controller's rule inverts it, and in Texas modifies delivered, which is interesting. So I mean, the controller's rule much more clearly supports your point, but I'm curious as to why the rule wouldn't follow the statutory language, but would instead invert it. And doesn't that suggest to us that in order to reach the result that the state wants here, we have to actually change the statute as it was actually enacted?
We read the statute as a whole. Each sale of tangible personal property, if the property is delivered or shipped to a buyer in this state, and even if...
Or the statute says that the property is delivered or shipped to a buyer in this state.
Correct.
Do you lose if in this state modifies to a buyer?
No.
Okay.
And that's an important distinction to make also. All these distinctions, I know they were briefed heavily about within, in, and modifiers, last antecedent. None of that matters in this case if we were to even lose those individual arguments, because based on the plain language of the statute, that is, the NuStar is a buyer in this state.
Because the buyer was in the state
Yes.
when they took delivery.
Yes.
Because I agree with Justice Young. It looks like in Rule 3.591E29A, and then again in your brief on page 6, it looks like the comptroller's changed where Texas goes. So page 6 of your brief says, the plain language of statute yields only one reasonable interpretation. Receipts are property sourced to Texas for franchise tax margin apportionment when tangible personal property is delivered or shipped in Texas to a purchaser. But if in Texas or in this state goes on the end, no difference?
Correct, no difference. And remember that the rules are not exclusionary, particularly that first one that you're citing. It's not trying to state the whole universe of what's considered a purchase in the state. These are examples of what's a purchase in the state.
So I hear you to be agreeing that, just as a grammatical matter, looking at the statutory text alone, that in this state modifies buyer.
Now, we're not conceding that, but we are stating that it does not make a difference.
If you were diagramming that sentence for your 9th grade English teacher, what would you say in this state modifies?
Probably buyer, but.
But as we asked your friend in opposition, if the buyer is in this state for purposes of where they took delivery, then you still win this case?
Correct.
And a version of this statute has been on the books since 1979 or thereabouts?
Yes.
And how long has this version of the rule?
This version of the rule has essentially been in place since 1969. So,
1969.
Yes.
So the statute's earlier than that, I guess.
Right. And there have been obviously revisions of the statute since then. But that's an important point, that essentially the comptroller has been taxing gross receipts the way that we are arguing here for decades. And any sort of change in that position would upend the system that's been in place for several decades.
Well, on that score, this dispute seems to be about 2 years, a refund claim for 2011 to 2013. What is the status of subsequent years? It's been almost a decade of additional years. How has the taxation, how have the receipts been treated since then?
I'm not sure regarding the NuStar's particular situation, but comptrollers continuously been relying on this rule and using it for decades.
Are there other apportionment, I just need to go back and look at the tax code, but I assume that for other types of property or services, there are statutory provisions that say those are taxed based on where they're used?
I don't know if I've seen those. They may be there.
Just wondering because that seems to be the other side's argument, is that the location of use is the final test, and I'm wondering if the legislature has chosen to sort of specifically call that out, the point of use, as the taxing, as what triggers the taxation in other contexts.
Correct. I'm not aware of
Not
any,
sure.
but
Okay.
they could easily be there.
Someone comes to Texas and buys a fancy car, looks around, buys it, but they live in Massachusetts and they have it shipped back to Massachusetts. How is that treated for franchise tax purposes?
So if it's shipped or delivered to Massachusetts, it would not be a Texas receipt.
But the buyer was in Texas.
Right, and there may be other taxes that are subject to it.
If they stop at Whataburger and have a hamburger, they get taxed on that kind of stuff while they're in Texas. But how about this sale?
Right, the sale for apportionment purposes would be if it's delivered, the property's delivered or shipped out of state, then that's the apportionment. There may be sales taxes involved. Those are separate taxes than an apportionment tax. But this is a tax on the buyer, the seller.
So the buyer being in Texas turns out not to be so dispositive.
Well, for apportionment, the buyer is in Texas, but the property also has to be shipped or delivered in Texas.
As I understood,
reading the whole statute as a whole.
As I understood Justice Young's hypothetical, the slick salesman says, you look good in that thing. I think you got to drive that deal off the lot. And you say, yeah, let's do it. And so buys it, and then buys it, takes delivery at the dealership, drives it off the lot, and then puts it on a trailer and ships it to Massachusetts. In that instance, was it then delivered to the buyer in Texas, even though they're then going to take it to the Commonwealth of Massachusetts later?
Yes, that would be shipped or delivered to the buyer in Texas.
So if he drives it off the lot into the trailer across the street, Texas, if the dealer drives it the 400 feet across the street to the trailer, Massachusetts.
Correct.
What if the buyer is a Texan who lives in Texas and never goes to Massachusetts, and buys the car to be shipped to a friend in Massachusetts? So you have a buyer in this state who's not leaving this state, and you have shipment to Massachusetts. Then what?
Well, if the buyer takes possession of the property in Texas.
He says, I want that car, send it to my friend in Massachusetts. I'm staying in Texas. I'm never leaving Texas. I'm as in Texas as you can be, and I'm the buyer. And I want you to ship it to my friend in Massachusetts.
Then that would be a non-Texas receipt if it gets shipped or delivered to Massachusetts.
So it sounds like when it really comes down to it, you want in Texas to modify shipment or delivery and not the buyer.
Well, we look at the statute as a whole. It requires shipment or delivery of the property to a buyer in Texas. And so it requires the buyer to be in Texas, but also for the buyer to receive the possession of the property in Texas, shipped or delivered in Texas. Shipped or delivered to a buyer in Texas.
So is the reason you're saying Massachusetts in that case because the property is not being delivered or shipped to the buyer, it's being delivered or shipped to someone else?
Someone else who
is not the buyer.
Who's not in Texas and not a buyer in Texas.
I'd be curious to get OSG's view on, I think 2018 Texas Health Presbyterian, this court said that we don't consider canons like last antecedent and serious qualifier unless the statute is ambiguous. But then we also use normal rules of grammar to determine whether a statute is ambiguous. So if you want to say hello to your 9th grade English teacher again, when should we use canons like this to try to understand the statutory text here?
Well, we should use it, as you state correctly, if the statute's ambiguous, but the statute here is not ambiguous. It's unambiguous that the property has to be shipped or delivered to a buyer in the state, in Texas.
So we don't use them to determine whether it's ambiguous? What do we use? How do we read the language to decide whether it's ambiguous if we don't get to try to interact with the text as a normal user of the English language would?
I mean, I think that's one of the tools that we use, but once again, I just have to go back to the plain language of the statute, and it requires property to be delivered or shipped to a buyer in this state.
If it is ambiguous, the other side wins, right?
No. If the statute is ambiguous, then we need to go to the next step, which is, one thing I want to also emphasize is Texas Tax Code 171.103A6 also covers quote-unquote other business done in this state.
So it's your position that the act of delivering or shipping property to a delivery point in the state can constitute business in the state, other business in the state?
Correct. And that's...
Has the comptroller taxed on that basis under A6 as the catch-all?
I assume so, but I do not know specifically. But that's something that we raised in our brief, and that is a fallback position if for some reason the statute's considered ambiguous. That type of language would still encompass the comptroller's rule here.
Is your position also that if the statute is ambiguous, that means that the way that you've written the regulation is okay?
Yes.
So that when there's an ambiguous statute, the controller can remove the ambiguity in favor of the state and against the taxpayer?
Well, once again, we're looking at one part of the statute, which is 171.131.
Just as a general idea, that's not right, is it?
Correct. So looking at A6, that would make the comptroller's rule valid here.
Well, you'd be saying, oh no, there's something else that unambiguously would allow this to happen, but that's not we're not remaining in the realm of ambiguity. If there is ambiguity, our cases say we favor the taxpayer.
Correct. That is case law on that.
Okay.
Yes.
Can I ask you, what does the phrase regardless of the FOB point or another condition of the sale, how does that work really in your interpretation? I'm a little unclear about that.
Sure. So with FOB, would only matter if the test centered on when the seller gave up possession and control. And it's relevant because excluding them would mean that these considerations would otherwise be relevant. However, they are not relevant if the focus on whether the buyer takes and uses property outside of Texas. So FOB, generally considers when free on board, when the risk of the seller transfers to the buyer.
The risk of loss.
Right.
The risk of loss to the goods is a point at which you denominate in the contract the risk of loss.
Correct.
And you could potentially make that the destination. You could make it international water. You could make it the point of delivery. You can make it a lot of different places. And so what does it mean that the statute says we're supposed to disregard that?
And I think that the purpose of that is to emphasize our point, which is because you're supposed to disregard that, you must look at the purchase, the delivery or shipment of the property and where that occurs to the buyer in the state.
If we agree that place of delivery is severed from buyer in Texas, who would constitute a buyer in Texas? I think your friend on the other side says a buyer in Texas would be somebody who is consuming or using the goods in Texas.
Right.
Would the comptroller agree with that or have a different position?
No, not yet. The comptroller would disagree with that and would look at whether the property comes into possession of the buyer in the state, either by delivery or shipment.
Or whether, sorry, go ahead.
Does the fact that the comptroller has been relying on its construction of the statute and its rule for half a century enter into the analysis at all? Or does it matter only if we conclude that there's an ambiguity here? How does that play in?
Correct. It would only matter if the court concludes that there's ambiguity, so the legislative acceptance doctrine. So.
Any further questions? Thank you, Mr. Rocco.
Thank you, Your Honors.
Ms. Ulrich, I believe you have 5 minutes.
Thank you. I'll pick up with the last question that you had, which is whether or not the doctrine of legislative acceptance would apply here. And NuStar's position is that it wouldn't. The parties both agree that we have an unambiguous statute, and when the statute is unambiguous, we do not apply the legislative acceptance doctrine. The comptroller's briefing had previously mentioned that this court might have already legislatively accepted the comptroller's rule, and that is incorrect. The Humble Oil case only concerns the construction of the rule for sourcing intangibles, not the tangible personal property that we're dealing with here. And then later in House of Lloyd, this court dismissed notions of ambiguity for 171, 103, and the doctrine of legislative acceptance again. And then ultimately in Lockheed, the court recognized that place of delivery versus ultimate destination was an open question that they need not decide this day.
So do you think the in-search case was wrongly decided?
I just think it's not applicable here. At the end of the day, that case dealt with, are we going to look so far as when the buyer ultimately resells it to another party? Is that the ultimate destination? We are not trying to look through the buyer selling to its own customer. So it simply doesn't apply on these facts, which is really focused on when you have a dog sale, that is what is happening in NuStar, coming in the state to pick it up and take it out. Is that going to be a Texas sale? This is not trying to look through where the vessel might resell it to somewhere else, to someone else.
You're focusing on the transient nature of the buyer, but the seller is a Texas company doing business in Texas and storage in Texas and all of that, and that is where the tax is placed. Should that matter at all?
Not when the statute requires us to look to destination. The legislature could have chosen origin-based sourcing that would make the seller's acts relevant. That is not what they chose here. So we need to look at destination and we need to look at the market. Now,
And again, those words just aren't there, and so I want to give you another chance to make your best argument grounded purely in the statutory text for where you want to get.
we have
Destination's not there, market's not there, use isn't there, dealing just with the words that are there, how do you get where you want to get?
At the same time, origin was not in the statutory language for services. It's a label intended to summarize what the words of the statute ultimately say, and to us, the to-a buyer in this state is what requires us to look to the ultimate destination for the goods. That is I'm hanging my hat onto a buyer in this state.
What do you think the best, I mean, this is supposed to be model language, right? And so there's some debate between the parties about how other states with similar language have construed the language. So what state Supreme Court to have looked at this language is materially identical to this one gives us the best textual analysis to reach your point? What would you recommend to us?
The Gilmore opinion from the Pennsylvania Supreme Court.
Okay.
They do the same thing that we're asking this court to do, a plain meaning analysis. And they, I think it's very persuasive, and they ultimately come out on the ultimate destination being the appropriate test, in part because as many opinions have recognized when taking up this language, they find it inherently problematic that the states appear to be trying to have their cake and eat it too by saying, if it's shipped outside the state by common carrier, that's fine, we're not going to touch it. If the seller delivers it to you on their trucks outside the state, that's fine, we're not going to touch it. But if you come here temporarily, we're going to catch you and we're going to tax it. So you end up having a situation in which the Comptroller's Rule says, source if delivered in this state, sort of cutting out to a buyer. Whereas for shipments, we ignore that initial in-state transfer of possession to the common carrier, and then they look to the ultimate destination for the goods, the buyer's location.
It seems to me that the textual disagreement maybe comes down to who's doing the delivery or shipment. Delivered or shipped to a buyer in this state, who's the subject doing those verbs, delivery or shipment? And he would say, it's just the seller. And you'd say, well, it's the seller, but it could also be the buyer who, further ships it. Or
The Comptroller's Rule makes the means of transportation, it dictates the outcome. And we say that that should be irrelevant. It is a condition of the sale, and it results to an inconsistent rule that is no easier for taxpayers to comply with than ultimate destination. So
How does that dovetail with disregarding the FOB point? Because it seems like, sellers and buyers can dictate the point of transfer of risk and the point of sale in their contracts, but the statute says, no, I'm not going to look at that. So
May I briefly respond?
I'm sorry.
yes.
I think the statute's goal by saying we disregard these contractual terms is trying to get to where are the goods actually going? Where is the buyer actually possessing them? We don't want games saying, I'm going to transfer title here, and that matters, so you can't touch it. Or I'm going to have FOB delivery here, so you can't touch it, Texas. So the ultimate destination test ultimately avoids gamesmanship like that as well by contract. Thank you.
I guess ask one last. Your friend on the other side answered me by pointing to the Utah Supreme Court's decision in Hercules. And I think that case is pretty much on all squares. You just disagree with the Utah Supreme Court's statutory construction, or do you have anything? And what's your main response to that?
My problem with the Hercules opinion is that the court ultimately allows transfer of title to dictate the sourcing outcome. They are not looking at the transfer of possession. The facts of that case are that title transferred at the seller's location when the goods were inspected, and then they were shipped by common carrier to Lockheed Martin outside of the state. So to me, that flies directly in the face of the types of terms that we are instructed to disregard under the statute itself.
Any further questions? Thank you, counsel. The case is submitted, and the court will take a brief recess.
Rise.